The trademark dispute in Blue Mountain Holdings versus Bliss Nutraceuticals ended with the 11th Circuit upholding the finding by the U.S. District Court for the Northern District of Georgia that Lighthouse Enterprises had issued a naked license to Blue Mountain, which covered the trademark that was the basis for the dispute. We're going to talk all about the naked license on this installment of the briefing by Weintraub Tobin. Thanks for joining us today. My name is Scott Hervey. I'm joined by my colleague, Eric Caligari. Eric, thanks for joining us today.
Thanks for having me, Scott.
Eric, can you give us some background on the case of Blue Mountain Holdings versus Bliss Nutraceuticals?
Yes, of course. Lighthouse Enterprises and Blue Mountain Holdings initially sued Bliss in April of 2020 for federal trademark infringement, federal cyber squatting, and federal trademark dilution, along with some other claims. The lawsuit was based on their ownership of the trademark Vivizan. Lighthouse claimed that it had been selling Vivizan products since 2012 and registered the name as a trademark with the United States Patent and Trademark Office in 2017. Blue Mountain claimed that it acquired the Vivizan trademark in a 2019 purchase agreement with Lighthouse. Bliss claimed that this purchase agreement was really a license. The district court agreed with Bliss and found that the purchase agreement was really a license and that this license became a naked license when Lighthouse failed to police Blue Mountain's use of the trademark. This resulted in abandonment of Lighthouse's rights in the trademark, and the 11th Circuit upheld the district court's findings.
While this case itself is very interesting and is probably far from being over, what I want to focus on today is the ramifications of the court's finding that the transaction between Lighthouse and Blue Mountain was a naked license. A naked license refers to a situation where a trademark owner grants permission to another party to use a trademark, and that trademark owner does not maintain proper control over the quality and nature of the goods or services associated with that trademark. In other words, it's a license that lacks the necessary safeguards to ensure that the trademark's reputation and distinctiveness are maintained. The nakedness of a license isn't judged by whether the licensor allows product quality to suffer. It's whether the licensor is keeping an eye on product quality and whether, in other words, it has abandoned quality control or not. If it has, the license is naked and the trademark is abandoned.
Yeah, and if a trademark is abandoned, whatever rights the mark owner may have had in the mark are also abandoned. It's quite a serious situation and result to avoid.
I agree. And given this, let's talk about how to avoid the granting of a naked license.
Yeah, sure. Well, first of all, when entering into a license agreement, that agreement should be in writing, and the agreement should fully outline the terms and conditions that the licensee must adhere to. These terms should include provisions such as quality control and the consequences of failing to meet those quality control standards.
And it's not enough that the agreement includes proper quality control language, but it's imperative that the trademark owner actually exercise proper control over the products or services that are associated with the trademark. This can include setting quality standards, providing guidelines, and periodically inspecting the products or services to ensure that they meet those standards. This was emphasized by the 11th Circuit's ruling, in which it noted that the record in the case showed that Lighthouse engaged in no meaningful supervision or inspection of the products bearing the Vivizan mark.
And in exercising its quality control rights, it's also important that there be consequences if the mark owner observes any deviations from the agreed upon quality standards and tries to enforce those consequences to make sure that they're being adhered to.
Agreed. The licensing agreement should include a clause that allows the licensor to terminate the license if the licensee fails to meet the agreed upon quality standards or breaches other terms of the agreement.
Agreed. And thanks for bringing this case to our attention for highlighting the pitfalls of the naked license and ways to try to avoid that outcome.
Absolutely, Eric.
Well, that about wraps it up here. Thanks for joining us on the briefing by Weintraub Tobin. Hope you enjoyed today's episode. Please remember to subscribe to our podcast and to our YouTube channel.